Well, hi everybody. Um, I have, I am glad to be joining you, from Juneau. Sorry I can't join you from Kenai. Um, and I just wanted, one of the things that am super passionate about, some of you may know this, is, copyright. And I love sharing it and talking through it with people. Um, and so to that end, I would really like this as much as possible to be a conversation, even though I'm not there in the room with you. Um, and I'm not sure exactly the best way to facilitate that, but I encourage folks, if you have questions, if you have comments, to not wait, but speak up. Um, I also I have a small apology here. I am reusing my slides from a previous presentation, and I did customize them, but I apparently neglected to customize the title. And so this really is a copyright Q&A. We are going to talk about relating to cultural heritage institutions, so it's not wrong, but it is also open to talk about issues that arise for researchers and others as well. One other thing that I'd like to show off before we get going, I long ago, um, I joined a copyright group with the ALA, and a friend at the state library, I don't know if you can see this, made me a copyright crown. And for years, I wore this whenever I did copyright presentations, and then I lost it. And I recently found it again. So you're you should feel honored to have the first copyright crown presentation in a long time. So one of the things that we do at the state library is, as part of the Department of Education and Early Development, we're we're required to go through the departmental mission, vision, and purpose. And the way I like to do this is to talk about how that relates specifically to us. And for us, we do work with children, but we work more with adults. And so we really take this into a lifelong learning um, context. Okay, so my ideas for today were that I would start off giving some basic background in copyright. But before doing that, I'll actually ask for maybe a little bit of feedback from you. I hate to go over the the basics if you all know them already, but I'm happy to if that would be helpful. So so finding out a little bit from your background in copyright would be helpful for me. Then I've gotten some scenarios for group discussion. We can use the ones I have, or even better is if you have any situations that you've dealt with recently or that you're dealing with now that we can talk through. And then I'll wrap up by talking about some really cool sources and opportunities for keeping up with copyright and for looking up things. It's a complex balance, and as a copyright geek, even I can't remember all of the years that that different that apply in different situations, and so I am constantly looking up dates myself. So first things first, um, does is anybody, can anybody share sort of what your backgrounds are and um, what you're interested in getting out of this session? We do have more time than some of the other sessions, so
See, Freya, this is Rachel.
yeah,
I can lead the way and I can sort of facilitate it from this end if you
that would
want.
that would be awesome.
Call on people to do it. But I'll tell you, my main interest in the workshop has to do with giving copyrights to people that we interview. We used to, I work at the National Park Service, and we used to offer copyright to people that we were interviewing and say, if you would like to copyright and that seemed to be impossible. So I just wanted to ask for your input on
That sounds like a really valuable scenario. We'll get into
yeah.
that.
Yeah, okay, so that's one of my main things, and also people bringing diaries and things that they've written and being interested in copyright. So so let me just see what other people in the room here have as their experience in it.
Just could stand near the microphone when they're speaking. It helps me hear better.
Okay, well, yes, brother.
Thanks. Yeah, Brent Johnson here. I know a lot of the basics about copyright, but I'm curious about a couple of things. One is there a length? For instance, I read something in a book and I want to quote, make a quotation. Is there a limit? Like if I quote a paragraph, how much can I quote and correctly source my copyright? Is there a limit to how much I can do? That's one question. And the other question is kind of more of a legal thing that has less to do with copyright. I'm curious, in writing a memoir, there's some events that have happened that involve other people that would put them in a sort of a bad light. I don't have any doubt about the truth of it. I don't have any doubt that I can have people verify this, but still, when you put people in a bad light, what are the risks?
Okay.
I'll just say the name of this person and just tell the truth, because without doing those two things, you got nothing.
Who else? David.
My name's David Ramser. I'm the president of the society and also the editor of the newsletter. I could use just a 101 on copyright. I sometimes get confused between copyright and permissions. Like
Yeah.
our newsletter, we are always scrambling at the last minute to get permission from the museum or somebody to use an old photo. And so it'd be worthwhile to have a little discussion about that.
Yep. Great.
Yeah. Yes, Phil.
Yeah, Phil White here. I teach Alaska history at UAF. My big copyright concern is I am working on a book about the history of the Trans-Alaska Pipeline System. And I just feel like, copyright in general, I know the basics, but a book feels just Herculean, like the number of copyright permissions that you have to get is so much higher. There's a lot more that you have to do there. So I'm curious if there's any advice that you'd give, folks who are still a couple of years away from actually publishing, but they have the kind of the opportunity to jump on, just get ahead some of the potential issues that you'd see in book publishing.
So I'm going to jump in right here because there's one little thing that I want to mention there that is not strictly copyright related, and we can certainly talk about that in a copyright context as well. But the one thing that I would strongly recommend for anybody working on any large project that you intend to, make public at some point, and that is to be really, really careful with your records. Make sure you know exactly where you got something from, who you got it from, the dates on it, the exact citation. That will be that. I mean, I'm sure everybody in this room is doing that already, but I can't emphasize that enough. And so I think that's probably the thing that will help the most, and I would go beyond what you actually need for a citation and just include any information you have to connect with, people you might need to get rights from. And then I would encourage you, where you know that you're going to need something, to go on and talk to that person or that institution right when you're getting that information, if you can, because it may be difficult to connect later on. Sometimes that won't work, but that's my number. That's my librarian hat rather than my copyright hat. Um, is there anybody else in there, or?
Anybody else? Yeah.
John Henley, one of the things I've noticed, I'm kind of in the same situation where I understand the basics of copyright, but it seems like as things are going more and more digital, it becomes more and more complicated. So something I would find helpful would be to get more information on the process of digitizing physical materials, what effects that might have on copyright, and what considerations you might have to keep in mind when you're going through that process.
And it looks like we maybe have some stuff on chat here. So it looks like there's some questions relating to oral history and to photographs or bodies of work. So I think what I will do is, it sounds like a lot of the questions that folks have do relate to what I had in my presentation. So we'll jump right into this. I won't, we'll go through it pretty quickly unless something comes up that you have questions about. And like I said before, please feel free to jump right in if you have a question or a comment as we're going through something. And I'll try to I should have written down all those questions. I was paying attention to them, but but so if we don't go into as much depth on something that you were particularly interested in, we can do that as we go or at the end, either way. So before I give any information about copyright, just my caveat, I'm not a lawyer and I can't give legal advice, but I am a librarian and I can give sources. Quite some time ago, probably, gosh, 15 years ago now, I went to a copyright symposium, helped plan it, and back in Maryland, in Baltimore. And this symposium was really eye-opening for me because it had a lot of people from sort of both sides of that balance of copyright. So there were a lot of lawyers, there were a lot of intellectual property lawyers that worked on behalf of major publishers, of major database companies, and artists and stuff like that. And my big takeaway from this huge fancy copyright symposium with all these bigwigs was the importance of basically looking nice. And I think this is a really important thing for folks to keep in mind. And how do you look nice? You be nice. And how do you be nice in a copyright context? You be consistent, you be fair, you be diligent, you be honest, and you communicate. And the way we do these things is when you're doing, say, a fair use analysis, you be consistent in how you do that analysis, whether that benefits you in that particular case or not. That's not saying that you need to bend over backwards to not benefit yourself, but you should be fair about it. be diligent in keeping records, to the extent that you should keep records. And be diligent in reaching out to people when you do need permissions. The the reason I belabor this so much is because I feel like copyright is often scary to a lot of folks. It's not always transparent. It doesn't always make sense to somebody who's not like in the midst of it, or even to somebody who is, which way something should go or would go. And the thing that became clear to me is that because the copyright law is written as a balancing act, there are very, very few, there are some, but very few hard and dried, cut and dried answers. Most things are somewhere in a shade of gray. And so, in that context, should something go to court or beyond just talk, then this can have a huge impact on how it plays out. So one of the things that that was brought up was talking a little bit about different kinds of things that are copyright adjacent, right? So one of the big things that we see in academia especially, but other places as well, is the connection with plagiarism. So those are both serious concerns, but they're not the same serious concern. But they do interrelate. So one of the things that can make you not look nice is if you don't give credit appropriately. So even though plagiarism doesn't necessarily result in copyright infringement, being careful about that can help you look like a good player. I won't really go into trademark and patent because I don't think those are as relevant in this context. But the one thing that I don't have listed here that did come up is privacy, and privacy is or sometimes it's called the right of publicity, and that varies from state to state. That's not a federal law; it's a more state to state. And so that can be really tricky. I don't get into privacy rights a lot, but it is important to know what they are for the state where someone would be covered. And that could vary. And this is where I'm not a lawyer. and so getting into the details of that are a little bit beyond me, but it is something to be careful about. Another thing that was brought up in the questions was talking about copyright versus access restriction. And I think that it was put as asking about getting rights. And you can be getting rights. That's sort of a, or clearing rights that, that term can be used in different contexts. So it can be used for clearing copyright or getting copyright permission, but it can also be used for basically licensing. And this is something that I think a lot of historical researchers run into, particularly when doing research at places like the historical collections at the state library or at the state archives or at probably any of the other larger institutions in the state that have these types of materials. And that is that we license the material, we license that use. And there are a couple of different reasons that I think most institutions are concerned about and reasons why they do that. One is they want to see that material used appropriately. A lot of what we have in our collections has been given to us by donors who are relying on us to take good care of their materials and see that they're treated fairly. And so that's a concern. Another reason is that we rely on those funds to help us have the money to do the projects, to get more collections, to digitize collections, to make them available. And the amount of money is, for most of us, relatively small, but it is not insignificant, and it can help us keep providing the services that we feel passionate about providing. There are other things that can come into it as well. But for most of us, in most cases, well, in many cases anyway, the material may not be under copyright protection anymore at all. It may just be that license. So oftentimes it is material that would be in the public domain. Sometimes, and this is another reason why we err on the side of caution, is that for many of our materials, we don't know. It may be hard to tell dates sometimes, particularly for personal manuscript and photograph collections. And so it's really hard to determine that. So when you're, particularly if you're considering publication or making it public in some way, you may end up needing to get both. So in many cases, the institutions that hold the physical items and license access to those items through fees for, say, a high resolution image. Oftentimes we don't actually hold the copyright. So part of what you need to do is determine whether something is in copyright. And then if it is, determine if you need to get permission, and then get permission from somebody else. And that's tricky. And we do our best to help, but we're not lawyers, and so we can't sort of give the answers, so to speak. So what can you use? You can use freely anything that is in the public domain that we're not limiting access to. So that means most U.S. federal documents. I have a typo here. It should be most publications older than 1928. I thought I fixed that, but apparently I missed that one. And some state publications. And then some other stuff. So there are different, the copyright law has changed over the years, and there are different rules depending on different times. And sometimes registration was necessary, sometimes renewal was necessary, sometimes they weren't. And so that makes it a little bit trickier. So with state publications, that varies from state to state as well. The federal law puts federal documents in the public domain, and that's most federal documents. Sometimes there's contractors involved, or they've used copyrighted material, or could be a lot of other things. But most federal documents are in the public domain. But they don't mention the states, and because they don't mention the states, the default is for them for state publications to be under copyright. Some states put their own states' materials in the public domain. Some states also put local government materials in the public domain. Some states do not, and some states just don't mention it, and so it goes with the default. Unfortunately, Alaska is one of the states that just doesn't mention it. And so by default, state publications do have copyright protection, and if they haven't aged out. In the past, getting clearance, copyright clearance for these publications was given to the departments, but officially it's the governor's call, and the last couple of governors have actually retained that right. They have not delegated that. And so generally speaking, if you're looking for copyright clearance, an agency may say that it's okay, but strictly speaking, you should get permission through the governor's office if you need permission. This is kind of sort of a little trickier than what you would think of for public domain. Public domain seems so easy peasy. Does anybody have any questions about any of this?
Freya, I have a question just about the 1927 one, 28. Is it 95 years or is
It's a rolling date, yes.
It's a rolling date, okay, so every year it's always 95 years ago?
Yeah.
Just to be clear, when we're talking about copyrights, I mean, for a lot of people who are, say, writing history, nothing is stopping you from quoting a document. I mean, you can always use documents and source them. So I guess I just to offer clarity, maybe. I mean, like
Right. There are, so these are the things, if something is in the public domain, you can copy the whole thing under any circumstances. You can take a book that's in the public domain, you can make a strict copy of it, and you can sell it. Because it's public domain. There are no rights with the creator anymore. So if something is not in the public domain, then there are still some ways that you can use sometimes even the whole thing, but definitely portions of it. And we'll get into that. But this is just that public domain piece.
So I have a question. Can you hear
Okay.
me?
Yep.
I worked for the state for a long time, and
Mhm.
they published a number of reports that I wrote and other people wrote. None of them have copyright notices on them. And as an individual creator, I've always understood that if I didn't put a notice on my work, I lost my copyright protection. So am I understanding that incorrectly?
It's yes. Sort of. um there are benefits to using a copyright notice, but and there are times when when under earlier copyright law that could make a difference as to whether it would still be under copyright or not, or whether it might have copyright in the first place. But at this point in time, um, a copyright notice is not required for copyright protection. Um,
If properly registered?
no, not if properly registered. Registration is not required for copyright protection at this time. At this time, the only requirements for copyright protection are that it have some level of creativity, because facts cannot be copyrighted, and that it be put into a fixed format.
Okay, so my photographs and my reports would both seem to qualify there.
But the diff but be, but that's the current, and there are um different rules at different times. And the other thing related to that is if you were making the photographs, if you were doing the reports as part of your work that you were paid for, it would most likely be considered a work for hire. In which case, it would be a corporate copyright to your employer.
Yeah, I
Now
played
that,
both sides of that street.
what?
I have both personal work and I
Okay,
have them work for hire. So I
yeah,
have both.
right. Sure, sure. So, sometimes work for hire is not clear. Often it's not super clear. Sometimes it's super clear. Um, if you're doing work for hire at this point in your life, um, I wouldn't, or at this point under the law, I would encourage having a written contract that specifies who gets the rights to the material that you create.
Agreed.
Okay, a little bit more about Alaska, and state rights. Um, although what I said about copyright um, applying for Alaska publications, there is a little twist of the state depository program, which the state library um, interprets to mean that we can make copies of any state of Alaska publications for anybody. Excuse me. And so this doesn't help you if you're publishing something, but if you just need a copy of something, you can, that is a state of Alaska publication, you can come to us. Excuse me. And if you're interested in using materials, sorry. Just gonna get a little. If you're interested in using materials from other states and want to find out about that, there's a really great. I'm sorry. This is a great source. You'll notice that Alaska's red because we're presumptively copyrightable. You can look at different states as well. And goodness gracious. And you can find more detailed information too. It's a really great project put together at Harvard. I hope everybody could see that when I went over to the, I just realized I didn't check. Could you guys see, can you see is it still showing the main presentation or did it go over to the,
It's still showing, the one that has the states and then Alaska versus others.
okay, then it didn't work as I was hoping it for it to.
So there you go. It changed over to the state library now.
Okay, I'm gonna do something really quick here. I set it so it would make a browser available. I'm trying to get the link. Can't do that. Arg! Well, I'll show you a different way. So one of the things that that you can have as a takeaway is this site that I've put together full of tools for figuring out things with copyright. It's lam.alaska.gov/owl copyright. And the reason is because initially I created it for an OWL program and I keep just modifying it and updating it. So if I go here, I think you should be able to see a state. I mean, a map of the country.
Yep.
Okay. So this is what I was talking about. You can see that Alaska's red, some states are green. And if you come up here to where it says states and pick a state, then it gives you just a ton of detail. And so it gives you all the relevant law and opinions and basically tells you what you can or can't do with state publications. It's a really great program. What most people rely on for using things that are under copyright, though, is of course fair use. And usually these are put in a different order, but I attended a presentation one time where she used the mnemonic PANE, P-A-N-E, and I liked it, so I stole it. And this is an example. It would be better if I remembered her name and could share that because it was a clever idea. But ideas are not copyrightable, only the expression of those ideas. So coming up with the idea of the mnemonic of PANE is not copyrightable. So we do have these 4 factors, and then there's actually sort of a 5th factor that comes more out of case law than out of the actual law, which is the transformativeness of it. So is this taking the place of the thing in the same kind of context, or is it turning it into something completely different? So we can go through these really quickly. The purpose and character of the use. Educational, nonprofit is better than commercial, or but again, but this isn't some people think that that is sort of like the master factor, and if it's nonprofit educational, then you're golden, and that is not the case. That certainly does argue for fair use, but it's not the only part of it. The amount or substantiality of the portion used in relation to the copyrighted work as a whole. So that it means, are you using, a paragraph out of a book? Are you using a few lines out of a poem? Or are you using the whole thing? It also means that substantiality piece means that if there is sort of the meat of something is a relatively small portion, but that's what people would pay to get the book for, or it's what makes people want that thing. If that's the portion that you copy, even if it's a relatively small portion of the total, then that could argue against you. There's an interesting case about this where a newspaper published an excerpt from a book before the book was published. And the excerpt was pretty much, it was a nonfiction, and it was pretty much the part of the book that would make people want to buy the book. And they said, but we only published this one small little piece. And the courts said, yeah, but it was the most important piece, and the newspaper lost on that one. So this goes to another question that had come up at the beginning about how much can you use? Can you use a paragraph? Can you use a line? And there are many guidelines about addressing that. Most of them are basically made up out of whole cloth and shouldn't be followed. So I've heard stories about you can use 3 lines of a poem, or you can use, I don't even remember the numbers. These mostly seem to be going around in schools, but they're not true. There are some guidelines that are in some published best uses, best practices, sorry. And I'll show you how to reach those. That those are not the law, but they are created by very thoughtful, long processes with experts. So it seems likely that they would provide good safe harbors, which is to say you might be able to do something more than what they said, but you'd be pretty darn safe if you stuck within those guidelines. But other than those that are actually, why don't I just pop right back there? So other than these codes of best practices, I would not recommend following any guidelines you say that say you can have that you can use a specific portion of something else. That's easy and it's nice, and we even kind of do it in libraries a little bit just out of desperation. But generally speaking, you need to do a fair use analysis. Nature is the nature of the copyrighted work, so purpose is what you're doing with it, and nature is the thing itself that you're copying from or using. And in this context, things that are more creative have more protection. Facts are not copyrightable. Facts presented in an obvious sort of standard way are not copyrightable. Facts presented in a more creative way maybe, although the facts themselves wouldn't, but the way they're put together maybe. And art or anything highly creative is has more and more protection. They used to say also, when I first started as a librarian and as a copyright geek, they used to say that the effect on the potential market value was sort of the one that trumped all the other ones. It was more equal than others. That really doesn't seem to be the case now. This is still an important thing to consider. But this seems to be one that sort of changes more over time. So first it was, well, I don't know, first when I was a librarian, it was the sort of the most equal among equals. Then it was not, but it really, the market, the potential market value was almost more important. And so even if something was not being marketed in any way, sold in any way, that you could potentially impact the ability of them for them to do that in the future, or it just was kind of it was a difficult one to work around. Now it seems to be more, if anything, this is somewhat less important than the others. Particularly if we're talking about vague maybes in the future kind of thing. So if somebody is marketing something right now and is selling something right now, then absolutely this is going to have that'll have an impact. If there's a licensing system where you can license through like the Copyright Clearance Center, we license articles. Then that will argue against fair use. Whereas if there's no way for you to pay anybody for it, then that will argue for fair use. Any questions on this so far?
There's a question here.
Yeah, there's a concept in software called abandonware, which is where if a piece of software hasn't been maintained, hasn't been updated in a long time, it's generally considered public domain, even if it's not legally that. Is there something similar in traditional media like art or books?
Not exactly. We have orphan works, and more and more institutions are starting to say, we can't find the copyright owner. They're not doing anything with it. We want to do something with it. Usually scan it and put it online and make it available to people, because talking about books and things like that. And so more and more institutions are saying, we're going to go on ahead and we're going to scan this thing. We're going to put it online. But they put a notice on with it saying, you know, if you're the copyright holder and you don't want this online, please contact us and we'll talk. And that actually has turned out to be, from the institutions that I've talked to who have done this, it's really been just sort of a win-win-win. They almost never get takedown notices, or get not notices, but get somebody contacting them asking them to take it down. In fact, they sometimes do get contacted by family members or the like, some people connected in some way. And more often than not, they want to share additional information or donate additional material or money. And so it has really worked out very positively for the institution. There are some circumstances where things have been taken down because somebody really usually had more of a privacy concern than a copyright concern. But and that can happen too, particularly with rights of privacy or copyright is not always the most important thing. So you may be able to put something online because of copyright. I mean, that may not stop you, but there may be other reasons why you might choose not to. And part of it, just earlier this morning in the presentations relating to Morningside, they were talking about whether the database should be freely accessible or not, and the different thoughts or potential thoughts from different groups. And there are times when we may not want to put something online because it may not legally belong to an Alaska Native group, but that doesn't mean it doesn't ethically or morally. And so, or even if you didn't get into that, then there are more selfish reasons why you might want to choose not to as well. Like, for example, you might not want to piss off the people that might give you more information or donate materials if you're an institution or whatever. And so there are a lot of reasons why you might choose to get permission when you don't need to, or to not make something public, even if you could legally. I think that's one of the most important things I love working with copyright law. It's a balancing act, and I think that's a really important balance for everybody. But I also am almost more passionate about paying attention to these other circumstances that may be sometimes more important.
And I
I
have
don't know.
the flip side of that situation.
Yeah.
Villages complain that scientific reports are inaccessible to them.
Hmm.
And so when I worked in a particular community, I would summarize the results of the research on a Wikipedia page for that community.
Hmm.
And I copied a screenshot of one graph from a 250-page report and put it in there with the paragraph that I'd written about the results of the research. And Wikipedia contacted me and told me to take it down. So how do I get permission to extract this tiny piece of a state-created work and allow Wikipedia to use it?
Wikipedia, Wikipedia has their own rules, and most publishers do. So a lot of times publishers have higher requirements than copyright law because they don't want any potentiality at all of getting sued over something.
Right, doesn't apply to the state. This is work created with public dollars. So
It
what
does apply to the state of Alaska. The state of Alaska has copyright.
as a moral principle, to
That's a different thing,
previous
yes.
example, can the
Yeah.
state withhold information from the public that it has created with public dollars for the public of Alaska?
No, but that doesn't mean that they have to allow it to be shared in the way that somebody else chooses to share it. So they may be required to publish it or they may choose to publish it. If they publish it, then we at the state library do our level best to get a hold of all of those. I have to say, state agencies are getting better and better and better about putting stuff online, but there's still, it was a pretty low bar. and and there's a lot of stuff that just doesn't make it. Um I think it's usually people not thinking about it rather, or not having time than anything nefarious, but it could be the other sometimes. But in terms of the particular circumstance that you're talking about here, facts are not copyrightable, but their expression may be. So I don't know about the graph you're talking about, the image. I know that Wikipedia tends to be really sensitive about images. And and if you took that information, if you took the factual information and presented it in some other way, you'd be in much, it would be more clear, you'd be less likely to run into problems.
It's an Excel pie graph. So
Okay, yeah. So not super creative.
no, so I could take the data and put it in an Excel pie graph and change the colors and call it my creation. But have I escaped the state?
You know, I generally try to like look at different aspects and work it out together rather than just give an answer. But I will say that facts are not copyrightable, and I would be shocked to find a standard presentation using standard tools through Excel without any sort of additional work to it. I would be shocked if that had sufficient creativity to cause any problem. Does that make sense in a sort of roundabout way?
Well, it does. This is a huge question and a pet peeve of mine, so I suggest we
Yeah.
move on, but I wanted to get your perspective on this. Thank you.
Yeah. And I will agree with you. As a librarian, there access to information is hugely important to me. It's a core tenet of librarianship. There are certainly reasons why information should not be made public sometimes. And there are things that we have in our collections that we don't provide to everybody because of the sensitive nature. Could be personal PII, personally identifying information. It could be health information. It could be sensitive Alaska Native information about Alaska Native, say, grave locations and the like. And so there are reasons, there are really valid reasons to not make some material public. But I think people are more and more understanding, courts are more and more understanding the need to have core public information. There's a lot of work being done for quite some time. We didn't think that most state laws were public domain, so you would be required to follow the law, but you couldn't see all the details of it because it was published by a contractor that that locked it up. And that's becoming less and less acceptable. So
Freya, we've come to the end of our time,
yeah, I
maybe we could just wrap it up.
yep, I can totally do that. Thank you. I was watching time and then I got sucked in. The one thing that I wanted to mention, this is the last thing that I actually really wanted to share, is there's a group in Alaska of copyright first responders. They're people who take a class from Kyle Courtney. He's a copyright expert at Harvard, and he provides these classes remotely and sometimes in person, and at no cost. And then there's a network set up so that we can ask when we get questions from people when we're not sure of what to say, we can reach out to each other for to sort of bounce ideas off of each other, and then we can do continuing education as a group as well. And we're right in the midst of a new cohort, so it's not the best time for me to be advertising it, but I encourage you, if you're at all interested, to get in touch with me, and next time we have a cohort, maybe we can get you involved then. It's a really great group of people, and fun and interesting and helpful.
Great. Well, thank you for bringing this workshop to us.
And thanks everybody for joining and for the questions. And if I didn't get to your question, please feel free to follow up with me afterwards. Either here or I don't know if we can here because there's probably somebody else got to use the Zoom, but let me go through to my contact. So feel free to contact me, and I'd be happy to talk through any questions or situations that you may have.
Great, thank you.
Thank you, everybody.
Right.
We just leave this.
If anybody wants, I'm going to be here. So if anybody wants to talk about anything until they take the Zoom away from us.
Yeah. We have a break now for the next 10 minutes, so we'll just leave it on, and then if anybody wants to talk to you, then they can continue. But
Freya, Brent Johnson here, and I have
Yeah.
a quick scenario. So I'm writing a memoir. Years ago, 50 years ago, I was dating a girl.
Mhm.
And her brother died in a cooking and fishing accident in 1973, the year I was dating her. So we went on and got married a couple of years later, and we're still married. And the local college, this college, was hosting a writers group thing for people to write stories, and a friend called and said, hey, why don't you come over and share something? And so I thought, hey, that story of that accident would be cool to share. And so I came over and I shared it. The accident itself never appeared in any newspaper back in 1973. Something I knew about, had researched a bit. A day later or so, the local newspaper, the Clarion, carried the story of this various writers that had shared poems and stories and whatnot, and they shared a bunch about mine. And there was another guy in the boat when the accident happened, and he lived. He called me up after this appeared in the Clarion, and he was really mad. And he said a lot of nasty things to me, including which you do not have my permission to ever use my name in a story that you might do about it. And I thought to myself, what a lot of hooey. Newspapers don't go around asking people's permission to put their names in this story. This is a factual event. It happened to my family. My wife is, her older brother was her hero. I got every right in the world to publish this. We're using his name. Am I right, or is he right?
I think in terms of copyright, you're fine. I'm not an expert in privacy rights, and I'm not 100% sure with that if there might be some privacy issues. I know they tend to be stronger in states that have like California, where there's actors and things like that. But what you're talking about, I mean, facts are not copyrightable. And you make a good analogy to news.
If I can butt in a little, the interesting thing is, I don't say anything derogatory about the guy at all. He was in the boat, What?
Yeah, right. Well, I mean, it kind of, I think, maybe goes back to part of what I was saying, where there are sometimes things, beyond copyright that are important. And, he maybe maybe read a lot more into it because of his own trauma of the experience.
I think that's true.
Yeah. So, he might not feel the same way now. He might not. It might be worth talking to him.
Yeah. I've known him for years, just a cordial, not like we're close friends or anything, but we
Yeah.
got well, and until the event when he called me up and was real unhappy, I was, like I say, shocked.
Yeah, yeah,
I got this and go, we're cutting into next people's time.
yeah.
Thanks a lot.
Yeah, I wish I had a straighter answer for you.
That's okay, I appreciate it.
Priya, sorry,
No worries.
we gotta reorganize our rooms here and get the next session going.
Absolutely. We were just talking until folks were ready.
Okay, thanks for all your time, and we really appreciate the intelligence you provided us.
Thanks.